Court is going to call 24 CRI 062, State of Ohio versus Deltino Crane. Matters before the court for a change of plea hearing. We are conducting that by remote video. The defendant is appearing from the Ashland County Jail. Mr. Crane, do you consent to having this hearing by video?
Yeah.
The defendant's attorney, Benjamin Kitzler, is also present. On behalf of the state are assistant prosecuting attorneys, Matt Medcalf and Jim Reese. It's my understanding the victim advocate is also logged in, as well as representatives of the alleged victim. This case was charged by an indictment on February 9th, 2024, setting forth 2 counts. Mr. Metcalf, could you state for the record what the plea negotiations are, please?
Yes, thank you, Your Honor. At this point, the state is prepared to dismiss count 1, aggravated vehicular homicide, in exchange for a guilty plea on count 2, failure to stop after an accident. That would be, the state would not be asking for a sentence today, but we'd be asking for a PSI, and then at sentencing, we would be asking for, I think, likely a maximum prison sentence on that count 2. I've had discussions with victim's family, many members of victim's family, as well as law enforcement and defense in this matter. I believe on almost all accounts, everyone thinks that that is a fair result, considering the evidence.
Mr. Kitzler, is that your understanding where the case stands?
It is, Your Honor.
And Mr. Crane, did you hear what the prosecutor had to say? I can't hear you, sir.
Yes, Your Honor.
All right. Is it your intention to plead guilty to count 2 in the indictment today?
Yes.
Okay. You understand if you do so, I'm not going to sentence you today. I am going to order a pre-sentence investigation, and we'll come back later for a sentencing hearing. Do you understand that? I'm going to need you to speak up, sir. We are recording this.
Sorry about that. Yes, sir.
All right.
Yes, Your Honor.
Mr. Metcalf, under Marcy's law, representatives of the alleged victim would have the right to have any input to the court they wish prior to a plea. If they're with Ms. Rayfield now, if any of them wish to make a statement before the plea, this would be with respect to the plea, not to sentencing. Obviously, they'd have a right to speak as sentencing as well.
Yes, Your Honor. I believe some of them would like to for change of plea.
All right, sir, if you could just tell me your name.
Terry Ramsey. I'm Mark Ramsey's brother.
What is it you'd like me to know?
Well, he was going to work and the truck broke down. The truck was off the road. And then Mr. Crane sideswiped the truck and killed him and throwed him 15 foot. Then he runs for 2 years, 3 months to the day. Now I don't know exactly how the law works, but I mean, I believe in justice. And okay, now he's willing to plead to hit and skip, but how about the murder behind it? He murdered a guy. A good guy has worked at Samaritan Hospital. He's coming on 24 years. And he never missed work. If he's on vacation, he'd go into work. If they call him in to go to work, he'd go to work. So I mean, he's a good guy. I mean, he was really he helped a perfect stranger. Now, if Mr. Crane would have stopped, that would have been good, you know. But a preacher stopped and he said he'd testify. A preacher stopped and helped him, and you know he was. How would I say this? He was mangled. He was crushed. He was absolutely crushed. And I found a tail light in the truck. When the truck got released, I found a tail light to the truck, And the investigator heard, she said, this is definitely a piece to the truck. And I asked him, did he have the truck impounded? Yes. I said, well, can I see it? He said, oh, it's way back in the back. But okay, they find him in Indiana. So I don't know. I got a letter. I wrote everything down. I mean, I think there's more to this than meets the eye. And my possession, I mean, my thing, Mr. Crane was willing to plead to the hit and skip. And then behind it, it says death. Okay. I think he should be charged with the hit and skip and the death of my brother.
Well, sir, I'm sorry. I'm sorry for your loss. Is there
Yeah,
anybody else?
thank you, sir.
Is there anybody else that wants to address me?
Yes, Your Honor, we have one more family member.
Okay, thank you.
Thank you, sir. Thank you for being here.
I just want justice. Oh. Oh, man. Yeah, you'd help anybody, I mean.
Hello, sir. My name is Jennifer Howard. I am Mark's sister. Mark was the man who not only did he work at his job at the hospital over here, he also would go to the doctor and nurse's house. He'd mow their lawns. He'd do anything, any kind of work for them they needed. If he seen someone broke down on the side of the road, there's a little black lady, bless her heart, was run out of gas at the side of the road, and my brother stopped to help her. And she didn't have a gas can. She didn't have any money. And my brother went and bought her a gas can, put gas in it, come and put it in her car, and then followed her back to the gas station to make sure she made it okay. And told her, go ahead and keep the gas can in case you ever need it again. He also helped Terry do his scrapping business. He also worked at the pantries, helping pass out food to people. And at the end of the pantries, whatever produce they had left over, they would give to my brother. And he would put it in his truck and he would run around to people that couldn't make it to the pantry to make sure they had some food. That's the kind of man that he left laying in the middle of the road. I mean, I wouldn't even do that to a dog. If I hit a dog, I would have to stop and check on the dog. If it was dead, I would have to pull it off the side of the road and bury it or something. I couldn't just leave him lay there. How could you do that to a person? If it was you, Mr. Crane, if it was you, would you want someone to stop and help you, or you think they should have drove off like you did? And I really have a problem with the fact that might only get 3 years for killing my brother. Accident or not, he ran for 2 years and 3 months. Didn't give nobody else no consideration to what he had done. And I'm telling you now,
I got something else to say.
my brother was a
Oh.
good guy, and he
There he is.
deserved a hell of a lot better than what he got.
Again, I am
And
sorry for your
Might
loss.
get 3 years for killing my brother, whether it's accident or not. The fact is that he's putting this off and putting this off. Now, all this time he's been in jail, you're going to take off of the time he would get for doing this. And that's not right.
How about
He ran for 2 years and 3 months. He shouldn't get any time off. Whatever he is sentenced, he should have to do the full sentence. No time off for being in jail. Because he ran for two years and 3 months. So he shouldn't get any time off for being in jail. Because of what he did. The way he did it. And I want to thank you for your hard work. And I appreciate you. And have a blessed day.
Thank you for being here, ma'am. Again, sorry for your loss.
He was such a good guy. Would do anything for anybody. They had no sense in this. And I don't know how Mr. Crane can lay down at night and sleep without seeing him laying there in the road. I really don't. I have trouble sleeping about. And I didn't even see him laying there. I just heard about it. And I have trouble sleeping about it every evening. Every night I think about this. My brother deserved a lot better. Mr. Crane, if you'd have stopped your car and went and checked on him and called the ambulance, he might have lived. But you couldn't bother to do that. Was you drunk or on drugs? I don't know, because you ran for 2 years and 3 months. He had a whole bunch of good stuff for everybody. And I'm outraged that you might only get 3 years.
They get more than that.
And I'm sorry about the accident. But I have 2 brothers left, and you took one of them from me.
I am so sorry you're going through that.
Well,
I am so sorry you're going through that.
Your Honor, if I may, I appreciate the victim's rights, but I don't know that they address the defendant or he addresses them.
All right, I'm gonna let you go. God
Good
bless
death.
you.
Thank you, ma'am.
Death on it.
Your Honor, we have one more family member, if that's all right.
Okay. Yes,
How you
sir.
doing?
If you could state your name and tell me what you'd like me to know about the plea.
Well, my name's Anthony Ramsey. I'm the oldest son of Mark Ramsey. And I definitely heard the end of my aunt's comments, and I totally understand and believe those too. Because for 2 years you ran. To me, that's sorry didn't mean nothing. I mean, I understand you can only tops get 6 years, even if you would play guilty to both. It's called, you should deserve more than time than even 6 years. But I told you, the prosecuting to get what they can, because I do understand law. And it's hard to prove the vehicular homicide because you ran. We don't know why, but we know you ran. Other than that, it's like, to me, that's gutless and heartless. I understand life is life. You never did nothing wrong, and I heard that. I just hope you understand that after all this, and I pray that you do have to have SR-22 for the rest of your life. That way, all your insurance companies know you killed a man, even though you didn't plead guilty to it. That's the main thing you need to have. Because in my opinion, you should never be behind the wheel again. But life understands you are going to get that right again. So please understand that people are people, not deers. Because you left like you hit a deer, and I know you didn't hit a deer, and you know you didn't hit it. And the other thing I need to say is, I don't understand why she isn't responsible for help hiding you for 2 years. The one who rented the vehicle for you. So in my opinion, she deserves time too. Whether that happens or not, I don't know. That is strictly on the courts. But you, sir, need more than 3 years. Now, outside of that, God bless. Because I understand in the long run, in order for me to be forgiven, I have to forgive you. And that's going to be hard to say. Because I do forgive you because of what you did. And I just hope you understand that. And with that said, have a nice day and God bless.
Thank you, sir. Mr. Metcalf, would you like to address any of the objections to the plea agreement?
Your Honor, I heard a lot of what the family has to say, and obviously this is a tough case. I've met with each person that spoke personally, kind of went over the evidence and went over the plea agreement. Everybody, for the most part, was on board when we had made that offer. I'm not sure they're off board now. It's just still kind of a tough case. I think, for all of them, but we have thoroughly discussed kind of the pros and cons of a trial, as well as the elements on count one, being that recklessly, that we thought might be difficult to prove. That's kind of where we landed with the, count two.
And that was my understanding from prior discussions was the element of recklessness would be difficult to establish based upon the evidence that you had. Is that accurate?
Your Honor, I don't like to get into that before a change of plea too much. You know, it's like strengths and weaknesses of a case, but I think that defense is aware of that as well.
And I'm assuming that's what ultimately factored into the decision to make the offer that was made.
It is.
Mr. Kitzler, did you have anything you'd like to say with respect to the plea?
No, Your Honor, thank you.
The court is finding that the representatives of the alleged victim were given notice and the opportunity to be heard with respect to these matters pursuant to Marcy's law. It is the prosecutor's authority to determine the strength of their evidence and to make appropriate offers based upon that. It's not the role of the judiciary to insert itself into those decisions absent bad faith, which the court is certainly not finding bad faith in this case. The court is aware that both of these are felonies of the third degree. This outcome does secure conviction to one of those. It is not an amendment. It is not a reduction. Certainly the animus behind both charges would be different. However, I think there could be an argument made that the conduct occurred at the same time, or at least partially inclusive of each other. So I'm going to permit the plea agreement. Certainly the representatives of the family have the additional right to be heard at sentencing. With that, Mr. Crane, you and I do need to discuss your rights on the record. I have no doubt Mr. Kitzler's gone through all of this with you, but I need to make a record of it. Could you tell me your date of birth, please, sir?
August 10th of 1977.
Okay. And how far have you gone in school?
My son college.
Do you have any difficulty reading, writing, or understanding the English language?
No, Your Honor.
Are you a United States citizen?
Yes, I am.
Did you take any medications, alcohol, or drugs today which would affect your ability to understand what we're talking about?
No, sir.
Do you suffer from any kind of mental illness or disease that affects your ability to understand things?
No, sir.
Are you presently on any kind of probation, community control, parole, or post-release control?
No, sir. No, sir.
Yeah. Do you have any other pending cases anywhere?
No, sir.
Is anybody threatening you or forcing you to plead guilty today?
No, sir.
Has anybody promised you anything other than what's been discussed here
No.
to get you to plead guilty?
No, sir.
I'm going to display on your screen a waiver of constitutional rights and plea of guilty form. Are you able to see that document?
Yes, sir.
All right, that does set forth count two, the potential penalties and consequences for that offense, as well as the rights you're going to be giving up by entering a plea. Did you sign that here on page 3 above the line? This is signature of defendant.
Yes, I did, sir.
All right, prior to signing that, did you have the opportunity to read it?
Yes, sir.
Did you have the opportunity to discuss it with your attorney?
Yes, sir.
Do you have any questions about this document?
No, sir.
Now, there is, Mr. Crane, there is going to be one change to this document. With respect to the license suspension, there is a mandatory period of suspension on the license under this charge. It's a mandatory class 5 suspension, which means at least 6 months to a maximum of 3 years of license suspension given that charge. Do you understand that change, sir?
Yes, sir.
Does that change your desire to proceed?
No, sir.
Have you
For the record, Your Honor, he and I discussed that when we had the forms.
Okay. Have you had enough time with your attorney in this case, Mr. Crane?
Sir.
Are you satisfied with his representation of you?
Yes.
Do you have any questions about the charge failure to stop after an accident?
Sir.
You understand the allegations as they're set forth in the indictment?
Yes.
Do you understand that a plea of guilty is a complete admission that you did commit those allegations?
Yes.
And as I said earlier, if you plead guilty today, I will find you guilty today. However, I will sentence you at a later date. You understand that?
Yes.
Now, this is a felony of the third degree. That does mean the court could sentence you to prison anywhere from 9 to 36 months. It does, however, go in increments of 9, 12, 18, 24, 30, or 36. There's a maximum fine of $10,000 there. There's the mandatory license suspension that we've already discussed. The court could also order any forfeiture or restitution that might be appropriate, as well as the court cost. Do you have any questions about those potential penalties?
No, sir.
This is not a mandatory prison term, so the court could put you under community control. If I did so, you would have certain conditions you'd have to follow. Those could include reporting, counseling, drug testing, that sort of thing. However, community control can also include local jail time or residential sanctions. If I put you under community control, I would reserve that 9 to 36-month prison term. And then if you violated the rules, you violated the law, you left state without permission, and you were found to be in violation of your community control, at that point, I could keep you on community control. I can impose additional or more restrictive sanctions, again, including jail time. I could extend community control to the maximum, which is 5 years, or I could revoke community control and impose a prison term from that 9 to 36-month range. Do you have any questions about community control? You're going to have to speak up, sir.
No, Your Honor.
If you are sentenced to prison in this case, upon your release from prison, you would be subject to an optional term of post-release control. It is optional in this case of up to 2 years. If you are placed on post-release control, the Adult Parole Authority would supervise you. Again, you would have rules you'd have to follow. If you violate their rules, they can send you back to prison on a rules violation for up to 9 months at a time. However, they could not exceed more than 1/2 of your originally stated prison term for all violations. If you were to commit a new felony while on post-release control, in addition to being sentenced on that new felony, that court could terminate post-release control and impose a consecutive prison term to anything you got on the new felony of 1 year or the time remaining on post-release control, whichever is greater. Do you have any questions about post-release control?
No, Your Honor. No, Your Honor.
With respect to your appellate rights, by pleading guilty today, you are waiving the right to appeal any ruling that the court might have made against you prior to today. Moving forward, any notice of appeal will need to be filed within 30 days of the court's sentencing entry. If you couldn't afford an attorney for an appeal, one could be appointed to represent you if you were found to be indigent upon your request. Likewise, the cost of an appeal could be paid out of public funds if you were found to be indigent. Do you have any questions about your appellate rights?
No, sir.
The last thing we need to go through are your constitutional rights. As you sit there right now, you've not entered a plea. You are presumed to be innocent. Do you understand that?
Yes.
Do you understand that you do have the right to have this case tried to a jury of 12 people?
Yes.
Do you understand at that trial, the state of Ohio has the burden of proof? That means they have to prove to all 12 of those jurors that you were in fact guilty beyond a reasonable doubt as to every essential element of the crimes charged before you could be convicted.
Yes.
You understand that you do have the right to have your attorney with you at the trial, and he could confront or cross-examine any witness put on by the state?
Yes.
You understand you have the right to have your own witnesses appear at that trial, and if they weren't willing to appear voluntarily, the court could subpoena them and make them appear.
Yes.
And then the last right you have is you couldn't be forced to testify against yourself at that trial, and if you chose not to testify, that fact could not be used against you to prove your guilt. Do you understand that right as well, Mr. Crane?
Yes.
Do you have any questions about your constitutional rights?
No, sir.
You understand by pleading guilty today, you are waiving those constitutional rights.
Yes, Your Honor.
Do you have any questions for me before we proceed to your plea?
No, Your Honor.
Do you need any additional time to talk to Attorney Kitzler?
No, Your Honor.
Mr. Crane, with respect to count 2, failure to stop after an accident, a felony of the third degree, what is your plea?
Guilty.
The record will reflect that the defendant is making a knowing, intelligent, and voluntary decision to withdraw any prior pleas of not guilty, instead entering a plea of guilty to the charge I've outlined. I am finding the defendant's been informed of his constitutional rights, that he understands the nature of the charge, the effect of a plea of guilty, as well as the possible penalties that could be imposed. I am accepting your plea of guilty to count 2 and entering a finding of guilty at this time. Mr. Metcalf, with respect to count 1,
Based on that admission, Your Honor, the state would move to dismiss count 1.
count 1 is dismissed upon motion of the state. Court is going to order a pre-sentence investigation be prepared. Mr. Crane, the deputies at the jail will have a questionnaire for you. If you run into any questions while you're filling that packet out, please contact your attorney. I am going to schedule the matter for sentencing. Mr. Kitzler, I'm looking at March 17th. Got a little bit of time in the morning or 1:30.
I will be out that week, Your Honor.
Uh,
Look at the week after. I'd appreciate it.
Week after, how about 10 o'clock on the 24th?
That would be fine.
Does that work for the state?
It works for me, Your Honor. Obviously, I know the victims want to be heard at sentencing.
Mr. Rayfield, if there's any objections to that date, if you could let us know.
That'll be fine, Your Honor. Thank you.
Court is going to schedule the matter for sentencing for Monday, March 24th at 10 o'clock. I will block off an hour for that. I think we'll need some additional time. Anything further we can do today, Mr. Kitzler?
No, Your Honor. Thank you.
Mr. Metcalf, anything further?
No, thank you, Your Honor.
All right, this matter will be in recess till March 24th. Thank you, folks.
Recording stopped.